I'm Vinnie Politan, the subject of my investigation, the upcoming trial of Lori Daybell, who has made the controversial decision to represent herself. Now, this is not the first murder defendant to make that choice. Ronnie O'Neal, a man charged with an unspeakable crime, also represented himself and cross-examined his own 8-year-old son. It was a trial you saw on court TV. Here's the story. Ronnie O'Neal III was convicted of a brutal double murder in Riverview, Florida on March 18, 2018. The violence was horrific. That night, he attacked his girlfriend, Kenyatta Barron, shooting her before beating her to death with a shotgun. He then turned on their 9-year-old daughter, who was nonverbal and autistic, stabbing her multiple times before setting her body on fire. O'Neal also stabbed his 8-year-old son, Ronnie O'Neal IV, but the boy miraculously survived and later testified against his father. During that trial, O'Neal chose to represent himself, delivering erratic courtroom speeches and accusing law enforcement of tampering with evidence. His behavior gained national attention, but the jury found him guilty. He was sentenced to life in prison without parole. His surviving son was later adopted by a detective who worked on the case. This was such a memorable case, but for really horrific reasons. The horrific nature of what happened to that little girl and to Ronnie O'Neal's girlfriend. That was a brutal, brutal murder. But then there was the trial. And what happened inside that courtroom was shocking. Ronnie O'Neal chose to represent himself, but then when he was himself, what you saw and what you heard from this man. Let's take a look at some of those moments from that trial.
And it might sound far-fetched, but I guarantee you, we're gonna see who the liars are before it's all said and done. Mark my words. The evidence is going to show I love my children. Are you sure that's how this scene went down outside of my house?
Objection, argument.
I just asked.
Okay, listen, wait, Mr. O'Neal, let me just rule on the question. Overrule the objection. You can answer the question. Are you sure?
That's how it went down, yes, sir.
Okay, I just wanted to hear it from your mouth. Did you see me beat your mom?
No.
Did you see me shoot your mom?
No.
She asked you who was getting the shooting, and you said, your mom. And she said, okay, did you see it? And you said, I heard it and saw it. Do you remember saying that to her?
No, I did not.
Were you able to draw any conclusions on whether I committed any murder in this case?
Yes, that's why I arrested you.
Did you say that I didn't kill Kenyatta Barron in self-defense?
I'm not going to say that, no. I arrested you for her murder.
And he stood over her, did this like striking thing like 3 times, and he shot her.
How many times was that again?
3.
3 times. And you're sure about that, right?
Positive.
Positive. You see 3 strikes.
Positive.
Do you see a call at 3:52?
No, I don't.
I'm gonna write it in.
Okay, again, you're just here to ask questions, not make comments. Mr. O'Neal, you need to speak audibly so that the jury can hear what you're saying.
Yes, ma'am. I haven't begun yet. I was talking to my father. His statements are contradictory to what he said before on the oath. You don't know what happened to my daughter. But you better believe I know what happened to my daughter, and that's why Kenyatta Barron is dead.
Now that you have been found guilty of first-degree murder, we now go into penalty phase. And as you are aware, it gets no more serious for any defendant in any criminal courtroom in this country than what you are facing now. I respect the fact that you chose to represent yourself, and I have to tell you, I think in another lifetime, you would have been an excellent lawyer. I really think that. You speak with great passion. I understood exactly the points you were making. I knew what you were attempting to get across in your opening statement, your cross-examination of the state witnesses, the direct examination of your witnesses, and your closing argument. Ultimately, your arguments were not persuasive to the jury, but nonetheless, I was able to follow exactly what you were trying to accomplish.
I am not sorry for something I didn't do, and I am not sorry for the things I did do.
What a case. It brings us to the first question in our investigation. And we're going to have a series of these questions for a series of cases. Did Ronnie O'Neal help or hurt himself? Now, you can take the easy way out and say, oh, well, he hurt himself. He got convicted. But he did it, right? So he was guilty. But did he help or hurt himself through his representation? The judge seemed relatively impressed. Let's talk about this. Joining us, he presided over the Anna Nicole Smith body custody case. Retired Judge Larry Seidel is with us, and psychotherapist and CEO of Life Counseling Solutions, Dr. Janie Lacey. I think there's a lot of different ways to look at this question that I'm asking. From your perspective, Judge Larry, what did you see from Ronnie O'Neal, and did he make things worse for himself by representing himself?
Well, Vinnie, you and I were trial litigators, and if he was in our courtroom, if we were representing him, we would have cleaned him up. He should have had a haircut. I mean, he looks like he's working at a carnival, the way his hair is and all of that. He's very aggressive in his tone towards the jury. He's almost frightening to the jury. I mean, he's a guy, you'd watch him in a midnight movie, and he would be the guy opening the door and says, follow me to go see Frankenstein. He's scary, he's aggressive, he's angry, and he's completely mentally ill. The judge is polite to him because why create more enemies when we're on the bench? There's enough danger for us walking the streets as a judge because we're sentencing people to these many years in jail. So we try to be polite about it. I one time sentenced a guy to life imprisonment, and I said to him, have a good day. He says, how can I have a good day when you just sentenced me to life imprisonment? He hurt himself badly. He should have had a lawyer who knows the rules of evidence, who knows the procedure. Yeah, O.J. Simpson had the dream team. Now, this fella couldn't afford 3 lawyers, but he should have had a lawyer, well be it that it's a public defender, but they have experience, and he would have done much better.
Dr. Janie Lacey, what struck a lot of folks was he did have a sense of what the issues in the case were. But as the judge pointed out, his tone, at times screaming, and everyone watching him had this impression, you know, there's something wrong with him. Obviously, there's something wrong with him for what he did, right? To his girlfriend, to his daughter, and to his son, who somehow survived all of that, and then he was cross-examined. But why do you think he chose to represent himself, and what impact would that have on him for the rest of his life as he's locked up, having gone through and represented himself at his trial?
That's a great question, Vinnie. You know, when I look at the Ronnie O'Neal case, I see this textbook example of how this self-representation can severely damage his own defense. You know, when we look at his charges of being the brutal murder of his girlfriend and his daughter and the attempted murder of his son, and then he presented himself with these explosive outbursts, these, you know, incoherent arguments, and even subjected his surviving son to cross-examination after his child testified about witnessing the violence. You know, when I think about this from the mental health perspective, you know, his behavior in court displayed, I would say several concerns if we look at it from that perspective, and his patterns, right? He had this grandiose presentation. He had this disorganized thinking when you really hear what he was saying, and his inability to even modulate his emotional responses, to me, suggests, obviously I did not do any type of examination of him, but it suggests that underlying mental health issues probably were never adequately addressed. And when we think about this extreme nature of his crime, also combined with this courtroom behavior, it's going to raise questions about his potential psychosis or severe personality pathology. But what made, to me, his self-representation particularly damaging was his inability to separate his emotional reactivity from the legal strategy. When we think about when defendants, in particular with untreated mental health issues, when they represent themselves, we often see this toxic combination of the legal incompetence paired with their behavioral issues that just creates this deep negative impression, I think, on jurors. So I would say it's probably been not addressed, and that's what we're seeing play out.
All right, when we come back, our guests are staying with us. Another case you saw here on Court TV, much different type of case. Up next, did Ty Tucker help or hurt himself?
This is all being made up and that you didn't do this?
Yes, this is it. That is my story all day. And I've said it since day one.
Grieving widow or mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The Celebrity Stylist Murder Trial. Weekday mornings, only on Court TV.
So now, I guess your story is that this is all being pinned on you, right? That you didn't do this.
You would know better than anybody, Mr. Mansfield.
Oh, would I?
Yes.
But I wasn't there. You were. So why did you tell me? Are you telling me this was all pinned on you?
I hate to tell you, again, Mr. Mansfield.
It's very simple,
You
Mr.
just
Tucker.
said
Is
that
your
I was
story
there, and you
today?
have no proof of
Is your
that.
story today that you were?
Sir.
This is all being made up and that you didn't do this?
Yes, this is it. That is my story all day.
Okay.
And I've said it since day one.
Very few will forget that trial of Ty Tucker down in Key West, Florida, accused in a botched robbery gone really, really bad. And he could have hired counsel of his choice. He was married to a woman who founded a very successful fitness company and had, access to a lot of funds. But he chose to represent himself. His trial, much different than Ronnie O'Neal's. Let's take a look.
A neighbor, Mr. Matthew Bonnet, heard the screams and decided to render aid, or at least try to assist in somehow. As he was coming up the stairs, the evidence will show that Mr. Tucker and Mr. Wilson confronted him. There was a struggle that ensued, and Mr. Bonnet was stabbed numerous times and eventually died from these injuries. The state is absolutely confident that at the conclusion of this matter, you will find that the defendant, Franklin Tyrone Tucker, is guilty as charged in the indictment and the amended information.
That was quite the story. But the problem is nothing in that story tells you what evidence they have, what evidence they're going to show. Now, how are they going to actually tie me into that story? Anyway, the prosecution, tells that story, but the problem is very little of that story is true. That's the bottom line.
Before I could pull away, I look in my rearview mirror again, and I see Tucker exiting the gate and running after my truck.
Did you tell them a different story prior to telling them the story you have now?
I have not changed my story.
Okay. Never?
There might have been some inconsistencies. Yes.
This whole case went exactly just like we thought. All this stuff that they've been bringing in, it's nothing but fodder, right? I haven't said anything that, says I did anything other than John Travis Johnson, who is, again, not very believable.
There's one other aspect of evidence that is going to be presented. So, Mr. Tucker.
I guess I'm calling myself to the stand.
All right. So, Mr. Tucker is going to be a witness in the case.
No physical evidence. right? So there's no physical evidence putting me there. There is no video evidence putting me there. There is no forensics evidence putting me there. Nothing. All the evidence the state presented. They still haven't even come up with a concrete narrative. To think that the jury is going to be able to ever come anywhere close to a verdict of beyond reasonable doubt, I don't see it.
If you all can't reach a unanimous verdict, then I accept that fact. I'm going to declare this case a mistrial.
Bottom line is they don't have a case. They never did. 6 years, and this is the best they got.
You'll recall there was no final verdict of guilty or not guilty at that trial. The jury was hung. And then at the end of the day, he took a no contest plea, time served, and he is a free man today. And that brings us to the next question in our investigation tonight. It's about Ty Tucker. Did Ty Tucker help or hurt himself representing himself? And I spoke to him several times. He just felt like he knew the case better than anyone. Still with us, retired Judge Larry Seidman and psychotherapist Dr. Janie Lacey. Judge, a much different result for this defendant. You know, a hung jury when I speak to defense attorneys, they consider that a victory. A pro se defendant getting a hung jury and then getting a time served, no contest plea, to me seems like a victory. What are your thoughts about Ty Tucker?
Well, this guy was much smoother. You and I might buy a car from him. He was calm, he was deliberate, he was well-spoken, and he looked like the jury. He looked like the average Joe. So what happens is, a fellow like this, in small claims court, most of the people represent themselves. And he's representing himself in a case that has tremendous consequences for him if he's found guilty. It's a hell of a risk to go to Vegas and throw the dice on this kind of bet. He was lucky, very lucky, and it's too much risk. He wound up with a hung jury. The evidence at times had some weaknesses in it. It's like a big balloon. As you know, a prosecutor has a big balloon and holes are being punched in it. And the jury bought part of what he said, and the jury was hung. They did not have a unanimous verdict of guilty against him. Too much risk and too much ego. For me, I want to win badly in everything I entertain. And I'll do anything that's not illegal or improper to get a win. But I'm trained in this game. I've been doing this 50 years. This guy just shot out of the cannon and did it. Too much risk. He got lucky. Very, very lucky. But let it not be a lesson for other people to be pro se, for other people to represent themselves. Way too much danger.
Let's take a listen. I spoke to him after he took that no contest plea. Here's what he had to say.
It's kind of interesting, though, because, the plea came about, and the reason I took the plea was, again, you mentioned the no contest part. That was a big deal for me because I was never going to plead guilty to it. They conceded that they could never prove me guilty of it. That was a problem. But rather than drop the case, instead of dropping the case as they should, they wanted their 10 pounds of flesh. And so I went ahead with this plea. But, I told them, point blank when we were doing the negotiations, I was like, look, if you can come up with something where I don't plead guilty and I don't do a single day's worth of time, no probation, nothing, then we can talk.
And he won that negotiation. Dr. Janie Lacey, what do you think's going on here, right? His whole life is riding on this. Like the rest of his life is riding on this. And he chose to bet on himself rather than hire an attorney.
What What I think about this, Vinny, is I think this is a clear case that demonstrates what we call the Dunning-Kruger effect, right? So there's this inflated confidence in his abilities, and we normally see this in people that have potentially higher personality disorder traits, right? So there's this overestimation, and they really have a cognitive bias that they are better than everyone else, and we see this play out in this overestimation of his abilities. In this case, it worked to his advantage, but we also know when defendants are self-representing themselves, there's a reality that sometimes they can fail to understand that they have to have this effective representation, which it's just not about the knowledge of the law, but it's about emotional regulation. And some of the clips that you showed, that he was losing some of that emotional regulation and the strategic thinking and all these types of things. So I see that there's almost this, he presents in a way that you can buy into that confidence, and it's almost inflated. And in this case, it clearly worked out to his advantage, Vinny.
Yeah, and how do you see him, like, from this point forward? We don't have a lot of time. We have about 20 seconds left, Dr. Jane Lacey. How do you think the rest of his life goes after having this victory and walking out of that courtroom?
I think he's probably going to walk around a little bit like Superman because he has this win and he betted on himself and he won. So there'd probably be no doubt that there would probably be more of that showing up in his life would be my guess.
Great to have your expertise and insight, Dr. Jenny Lacey, and of course, Judge Larry Seidlin, always great to spend time with you. All right, up next, we are not done. Did Darrell Brooks help or hurt himself? I'm Vinnie Politan. We continue our investigation of the upcoming trial of Lori Daybell, who will be representing herself, just like Darrell Brooks, who represented himself after plowing his car into a crowd of people at a Christmas parade. Here's the story. Darrell Brooks was convicted of carrying out the deadly Waukesha Christmas parade attack in Wisconsin on November 21st, 2021. That afternoon, Brooks drove his red SUV through a crowd of parade participants and spectators, killing 6 people and injuring over 60 others, including scores of children. The victims ranged in age from 8 to 81. Brooks had been fleeing a domestic disturbance when he intentionally plowed through that parade route. Despite efforts by police to stop him, he continued at a high speed, striking numerous individuals in his path. During his 2022 trial, Brooks chose to represent himself, frequently disrupting the proceedings with outbursts and bizarre legal arguments. The jury ultimately found him guilty on all 76 charges. He was sentenced to life in prison without parole. And that attack left the Waukesha community devastated, turning a joyous holiday event into a tragic and unforgettable day of mourning. Incredibly sad case. I just remember it was the range of people. There were children in the parade. There were older seniors in the parade as well. And just plowing through there, taking lives, hurting people. It was difficult. It was a difficult case for that community. But then things got even perhaps more difficult for them because the defendant, Darrell Brooks, who clearly had issues, decided that he was going to represent himself. And things didn't go smoothly like they did with Ty Tucker. Even Ronnie O'Neal, his trial would be compared to this trial, night and day. Darrell Brooks was disruptive and going at it with the judge. Take a look.
Dean, sir, is that you must follow. Yes, you're being disrespectful because you're not.
I'm not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeit his right to be present as I go through
I have not consented to any.
his paperwork. He's to be removed to the other courtroom until such time as he can pledge to follow the rules of decorum and civility. I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good note,
I didn't
sir.
roll my eyes at you, so I don't think it's fair that you should say I rolled my eyes at you.
I saw you roll your eyes at me, and that's
I didn't roll my eyes at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I would
rulings,
too, Your Honor.
let me finish.
You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back up.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the jury
Are you telling me to be quiet, or are you asking me?
I'm asking you and advising you.
Okay, thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do. Nothing about this is a joke.
I never.
That's what y'all don't understand.
But there's
and it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that? Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I think, Your Honor, with all due respect, I think you should show some respect.
Do not interrupt, Attorney Opper.
So
Your Honor, I believe he has 7 prior criminal convictions. We have OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003. Criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Like, you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1.
In my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement.
Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them.
I'm trying my best not to remove you to the other courtroom. You may not raise the issue of jury nullification in front of this jury. If you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law? Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. I reject that ruling and take exception to that ruling.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of...
Hey, you are to be removed right now.
Looking back on that case, what did he expect the result to be? Or was he so mentally damaged that he didn't fully understand or have some perspective on it? That brings us to the next question in our investigation. It's the question we've been asking all night for these folks representing themselves. Did Darrell Brooks help or hurt himself? There he is with his objection sign, and he got sent to the other courtroom. Joining us, trial attorney, fellow of the American College Trial Lawyers, Ann Bremner, and clinical and forensic neuropsychologist and author of the book, The New Rules of Attachment, Dr. Judy Ho. Great to see you both. Ann, how different would the representation of Darrell Brooks have been with a lawyer? Because I'm wondering if there could have been a different result here. The evidence was pretty clear, video, everything. They had everything on this. But what are your thoughts about how the trial may have been different here?
I don't know if it would have been. He plowed through all these people in traffic, and he just plowed through this trial. I kept wondering during this trial, why is this judge letting this happen? I mean, he obviously has mental issues. I've had cases where pro se litigant made all the pleadings into paper hats. I mean, you can't have that. I mean, you've got to have somebody that's able to present. And someone this disruptive, I mean, of course he hurt himself. I mean, he annihilated himself, including at sentencing. It went beyond just the evidence. But the fact is, you had a totally disrupted trial. You had, I think, a real impact that was negative on the victims and the justice system. And he did hurt himself, but would it have been different with a lawyer? It certainly would have been civilized.
Dr. Judy Ho, what's going on here with Darrell Brooks? Why does he choose to represent himself? Does he have any understanding of what's really happening here, or is it a choice so his voice gets heard literally every day during this trial?
I think you're onto something, Vinny. Most of the times when people choose to represent themselves, it's because they think that they can do a better job than anybody, including trained trial attorneys. And that takes a certain type of personality to believe that about yourself when you've had no training and no experience, that no one could represent you better than yourself. Of course, as you mentioned, there is a minority of people who they are just not ready for trial. And there's different reasons for that their mental capacity is unfit for trial. And there's different reasons for it, including maybe a cognitive issue or a psychological issue. For example, they're actively in a state of psychosis. Based on this video footage that we're seeing here, it doesn't necessarily look like that's what's going on here, where he doesn't know right from wrong. I think what we're seeing is that he insists that he is in the right, and he doesn't think that he's being disruptive to the court process, realizing that she has a huge say in terms of how this trial even goes, whether or not he makes certain arguments, he's still arguing back. And so I think we're seeing a different portrayal here of a person who just so overly believes in themselves that they think that they're the best person to represent in court.
So, Ann Bremner, describe for the folks at home what would happen if an attorney spoke to a judge the way this defendant spoke to the judge, just so we have a little bit of comparison as to what happened here.
Yeah, the first time an attorney did that, they'd be held in contempt and put in jail. I mean, it's so disrespectful and so inappropriate. Yeah, I couldn't watch that trial. I can't even watch what you're just putting out here again. It was so offensive. But Vinny, that if you did that or I did that, we'd be held in contempt. We'd either be removed from the case, or removed from the courtroom, or removed into jail. The court has inherent contempt power and can exercise it. That's what would happen to a lawyer.
And the state bar might be sniffing around as well.
Yes,
okay.
Right.
Ann Bremner,
Yeah.
Dr. Judy Ho are staying with us, because when we come back, the ultimate question for the trial that's coming up: will Lori Vallow, Daybell, help or hurt herself?
And I have real trial experience. I have participated in 3 different full trials from beginning to end.
Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial begins Monday morning on Court TV.
Breaking down the week's big hearings from the most anticipated trials in our daily spotlight. Plus, a closer look at true crime cases with our voice for victims.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors took my there.
Gotcha.
I didn't see the shot, it hurt, and then I came back around and I saw that he was on the ground.
I was told by Jesus that I needed to go back and complete things that I had covenanted or promised to do before I was born.
I thought Tylee did it to get back at me.
Lori Daybell has a murder trial coming up right here on Court TV this spring out in Arizona for the murder of her husband, Charles Valla, who was shot and killed by her brother, Alex Cox. Lori's already serving life without the possibility of parole because she murdered her children and had a part in the murder of her husband's wife. But now, for her next murder trial, she is going to represent herself. So let's take a look at some of the work that she has done as you have lawyer Lori representing herself in Arizona.
For the past 5 years that I've been incarcerated, I have taken upon myself to study case law and criminal rules of procedure in the state of Idaho and Arizona, as well as federally. Prior to that, for the last 10 years, prior to my incarceration, I did study procedure in family law, and I have real trial experience. I have participated in 3 different full trials from beginning to end. The detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people. Then I have them coming up, and they're going to be on the stand, and they're going to be in trial, and they're going to be saying what they reviewed. They've reviewed all these things, and there's communications between all of these agencies that I feel like that the defense is privy to. Today, the defense is requesting that this court do the following 3 things. 1, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also ask that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
It's going to happen. It's happening. Brings us to the next question in our investigation tonight, and this is the big one. Will Lori Daybell help or hurt herself? She's not stupid. She's not stupid. And her brother is the one who actually shot and killed her husband. But what's going on here? Still with us, trial attorney Ann Bremner and clinical and forensic neuropsychologist Dr. Judy Ho. I'm going to start with Dr. Judy Ho on this one. What's really going on here? I know she's serving life without the possibility of parole, but what do you think is the motivation that she has to represent herself here?
It's an interesting question, Vinnie. And I think that because the first trial did not necessarily end in peace, she's saying, hey, let's do this ourselves. Maybe I have enough experience. I thought that it was very interesting that she said, I have trial experience from 3 full trials. That is very, very different. You are not an attorney. You do not have trial experience as an attorney. And nevertheless, I think she's thinking maybe I'm going to get a different outcome. So it's not so different from what we talked about in the last segment with Darrell. She believes that she is the best person for the job.
Ann Bremner, what do you think is going on here with Lori Daybell, and what do you think this trial is going to look like?
Well, I don't think it's going to be a pretty sight, Vinnie. I mean, I think that, remember kind of the things she talked about at the end of the last proceedings where she didn't make any sense at all, and then in her background, some of the delusions she's had. I bring that up because we know that she was found not to be competent previously. So looking at that and looking at basically her mindset, I don't know where she's going with this thing, but I do know what she just iterated here in her list was kind of scary because she doesn't really know what she's talking about. And I think it's going to be yet another one of these farces where she, you know, she likes the attention. Like, we look at her right here. I mean, all of the kind of, look at me, you know, all this kind of thing. Even though she's been sentenced to life without parole, she escaped the death penalty only because the state didn't meet their discovery obligations in Idaho, as you remember. So I just think, why did these judges let this happen? She could have standby counsel. She could have, you know, more of a
Let me
limited
ask you
role,
this, because competency has been an issue, right? And usually that is something that's brought up by your attorney. How would that work here if she starts to decompensate to a certain extent and starts to break down? Can a judge order an evaluation just on their own?
I think they should. You know, it's the same kind of thing. The judge has an independent obligation on certain matters to step in, and this would be one of them. You cannot let somebody in a case like this represent themselves with what we know about her and her competence, and what the judge, I think, will see in this trial. I think what we're going to see.
Dr. Judy Ho, she's used to speaking. She was a podcaster.
That's right.
She was. I mean, it's like a real thing. And she had people who were seemingly following her and Chad, right? Because they were the chosen ones, and they had a group. So she learned how to, I guess, influence people to a certain extent. And I'm wondering if she thinks she can do the same thing with the jurors. Do you think this will be a serious defense that she'll have, or will it be more of just taking the opportunity to say what she wants to say about, I don't know, the doomsday that's coming, her love for Chad, I don't know, the zombies, or do you think it'll be a serious defense and she believes she can influence people like she has in the past?
Well, Vinnie, I'm not sure if it's going to be a serious defense, but I think that in her mind, she believes that she can seriously charm people. And just as Ann pointed out, her list that she iterated probably didn't make much sense, but actually the way she said it, if you listen to her tone, she seems confident in herself. She had a very confident tone. And I think that that is one of the ways that she has influenced people. I would also say too, that when somebody has some form of delusional disorder, which it appears she might have, delusional disorder is very exclusive to the delusions themselves. So the rest of the time, the person could be walking around totally making sense with other issues. They seem competent otherwise, but it's really when you delve into the delusions that you say, wow, something's going on. This person might have a thought disorder. So just with commonplace conversations, you may not even be able to tell that they're suffering from a psychotic illness.
Ann Bremner, we have about 20 seconds left here. Do you think any jurors might have any sympathy for her?
No. I hate to be brutal, but I don't think so. I'd say that's a no.
A big no. Yeah. And Dr. Judy Ho, just 10 seconds here. How do you think jurors respond when it's the accused killer themselves who is talking to them?
I think it feels a lot more personal, but also they can get down to the truth very quickly when it's the defendant talking. And usually they talk too much.
Yeah, I think it's a great truth detector as well. Dr. Judy Ho, Ann Bremner, thank you so much. We'll see you again soon. Now, I don't expect many outbursts by Lori Daybell at her trial, but I do expect some strange, unpredictable behavior. She's not stupid. She may have some extreme beliefs, but I think she'll play this one to win. I don't think she's going to hesitate one moment to drive her crazy bus right over the body of her dead brother, Alex, and just point the finger at his corpse. I mean, she already murdered her children. What would stop her from making her brother the fall guy? I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.